What happens to your property if you pass away and you have children outside of your marriage? Who gets what? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to tell you a little story about something that happened in one of my probate cases. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarochala.com. There you can schedule a free strategy session with me by going through my calendar. You don't even have to call in. You can do all of this online. It's very convenient. Or you can call in if you prefer. You can find me on social media. I'm at Amanda Rocha Law on almost every platform. And finally, you can always comment down below if this platform allows you to do that. So what happens if you're married and you have children outside of your marriage? Who receives what if you pass away without having a trust or estate plan in place listing who gets what? That is called intestate succession, when you don't have an estate plan and you pass away. If your property reaches the level for probate, which in California currently is $184,500, then your property passes through probate. If you have less than that, then your property passes outside of probate, but it still goes to the same people in the same order. So what happens? There are lots of different combinations. I am going to give you the most common one and a couple others. And this is what happened on one of my probate matters. So person passes away, they are married with a spouse, and they have one child with that spouse. They have one child from a prior marriage. In this situation, the spouse that passed away acknowledged the other child as their own. It wasn't as if it was a person that they never knew of or said was not their child. They have provided for this other child outside of the marriage all along, and so that was pretty easy for us in probate. We weren't going to have any arguments there. What happens is when you pass away and you're married, you have community property. That's property that's shared in the community of the relationship between spouses. When you pass away, the community property immediately transfers by operation of law to the surviving spouse. It's the separate property that we have to make a calculation for. In this situation, the separate property was split 1/3 to the surviving spouse and 2/3 to the surviving children, regardless of whether the children were inside or outside of the marriage. And in this situation, all the children were adult children, so it wasn't as if they had a guardian to worry about. But that 2/3 of the separate property, which in this situation happened to be one house, that house was split 1/3 to the surviving spouse and 2/3 to the two surviving adult children. It can change if there are different situations. So if you don't have any children in your marriage and you only have a child outside of your marriage, but it's one child and you've acknowledged that child, then it will go 50-50. 50% of the separate property goes to the spouse, 50% of the separate property goes to the one surviving child. It gets complicated based on grandchildren of deceased children and whether or not you accepted that child as your own or acknowledged them. So if you have questions about this, please reach out to me. I'd be happy to help you with your probate matter or to give you some direction. You can comment down below if this platform allows you to do that. You can find me on my website, www.amandarochala.com, where you can schedule a call with me to discuss your issue. Or you can follow along on social media and send me a message that way. I'm at Amanda Rocha Law. Thank you.